Assalamu alaikum wa rahmatullahi wa barakatuh, and welcome back to another episode of Legal Ease, the show that converts legal jargon into legal ease. Now, tonight we are rejoined by a previous guest and very well-known advocate who I'll introduce in a moment. But just by way of background, what we're discussing tonight is the topic of emolument attachment orders. Now, debt recovery has always been part of the law and the economy. But recently, some creditors have used shortcut processes to try and enforce repayments of the loans that they give out, especially in the micro loans industry. And they have a minimum of court interventions when they're trying to enforce their claims. Now, emolument attachment orders is a favored process where the clerk of the magistrate's court, on the strength of a judgment debtor having consented to the issuing of the EAOs. Now, this process is open to abuse because of the absence of any judicial oversight, and particularly because no evaluation is done of the affordability of the amount to be deducted from that employee's salary. Recently, on Wednesday, the 8th of July 2015, the Western Cape High Court declared this practice unconstitutional, and certain sectors of the Magistrates Court Act regarding emolument attachment orders was discussed. Judge Desai's decision had the following effects, which we will talk about at great deal today. One, that this process was open to abuse because of the absence of any judicial oversight, and particularly because no evaluation was done on the affordability of the amount that was to be deducted from the employee's salaries. In certain cases, as high as 60% of the monthly salary was attached and removed. The second leg of that was emolument attachment orders may no longer be issued by the clerk of the magistrate's court on the strength of the fact that the judgment debtor has consented to the order being issued. And now it is no longer possible in a credit agreement to which the National Credit Act applies for a debtor to consent to the jurisdiction of the magistrate court outside the area in which the debtor either resides or is employed. Now, the practical effect of the judgment is that all emolument attachment orders issued by the clerk of any magistrate's court is invalid. Henceforth, emolument attachment orders may be issued by the magistrate in an open court, and where they arise from an agreement regulated by the National Credit Act, they must be issued in the area where the employee resides or works. Now, in that case, the Human Rights Commission was joined as amicus curiae, which means friend of the court, and helping us better understand the impact of the judgment and the role of the amicus is none other than Advocate Mohamed Shafie Ameermia, who is a commissioner with the Human Rights Commission and who was entrusted with oversight in this particular case. Shafie, assalamu alaikum.
Wa alaikum salam to you, Ashraf, and to your listeners.
And Shafie, thank you for coming in, and welcome again. Now, first of all, let's talk about, we've done the Human Rights Commission previously, but just briefly, what is the Human Rights Commission, how is it established, and how would it compare to, say, something like the Public Protector?
Okay, the Human Rights Commission is a Chapter 9 institution. It's a constitutional body. Okay, it is different from the Public Protector because we deal with human rights issues and abuses. We champion, we advance the promotion of the Bill of Rights, respect for and the protection and enforcement of those rights, and also we do a monitoring and evaluation and the observance of human rights in the whole of the Republic of South Africa. Mm-hmm. A Public Protector, on the other hand, deals with those malpractices that are confined to the state itself. and how it spends its money and so forth. So it's completely different from what the Human Rights Commission does. Our mandate is wide and is vast. Our reporting is to the Portfolio Committee in Parliament, and we have to go annually to to Parliament to respond to the observance of human rights in this country. And then obviously coupled with that, it's also the international best practices that factors into local jurisprudence on how human rights is developed in this country, in line with the 27 rights that are enshrined in the Bill of Rights. That's Chapter 2 of the Constitution.
Okay, so thank you for that background. Now, with regard to this particular case, how did the Human Rights Commission become involved in it? And then tell us what role you played before we actually get into the judgment itself and what it really means for this industry, as well as for those parties who are affected by the emoluments attachment orders.
I think first of all, Ashraf, I'd like to say that what has happened is, my portfolio at the Human Rights Commission is I'm mandated to do the Access to Justice program, which is a national program. And given that we are 7 commissioners and 180 staff, it is impossible for us to reach the length and breadth of South Africa to touch the souls of 50 million souls in this country. So we have to do what we call linkages, and those linkages is that we go to institutions that also work with the poor and the vulnerable, like the law clinics. In this particular instance, I went to the Stellenbosch Law Clinic to kind of forge an alliance with them on public interest law matters. And they welcomed me because they said, we have a very big case here. It's a David and Goliath story here, where we are championing the rights of farm workers who are working in the Doorns area in the Western Cape, and their rights are being trampled upon and they are being put into poverty traps. Having understood what the problem was, it was to do with the whole micro-lending industry in this country. That basically was a cause for concerns for the Human Rights Commission. So what we did as part of our thematic focus area for this particular financial year, we then embarked on what we call business and human rights as a thematic program, where we engage civil society to find out exactly what is going on in this particular industry.
Yeah.
When we did that, it was like opening a Pandora's box.
Yeah.
We then went back into our own records, as far back as 2008. The University of Pretoria, in their research, made noise about the abuses that are prevalent in the microlending industry. In 2013, Praveen Gordhan goes on air, when he was a Minister of Finance, and he says we need to interrogate all emolument attachment orders, and to ensure that they are properly issued.
So the warning bells were there, but no one really took notice.
That's the point. And now, where does the Human Rights Commission come in? I think the Human Rights Commission then reflected, did introspection. And then we said that we are a constitutional body, and where we have to advance and champion the rights of poor people and the vulnerable people, like the debtors in this case, we must do so without fear, favor, or prejudice. And so what we did was we said to the Stellenbosch Law Clinic, we'll join you. So we got our mandates from the Commission. We went to Parliament and we raised the issue in Parliament, and we said to the Parliament that this is a matter that is of national interest because it's eating away into the national economy as such. Just to give you Ashraf, an insight into how big this industry is. This industry grew from, in 2007, the micro-lending industry, from 41 billion rand to, in 2013, to 159 billion rand. Now, one asks yourself this question, how is it possible in a country like ours to have such a big business going on? And what are the underlying things? So the Pretoria University research report, which we then took, we then found that what was happening is that the credit providers, that is the debt collection industry, they had there were 45 of them that were part of this case. And they had 150,000 credit, debtors on their books. When we translated that, it translated into 1.6 billion rand. Now that is phenomenal.
Yes.
Why it's phenomenal? Because if you look at farm workers, there were some farm workers, a woman, a mother, a single mother, borrowed 250 rand, just to give you one example.
Yeah.
She had to pay back 7,900 and some odd rands back, and she still continued paying. So what does it do? It puts people into poverty traps. Now, if you thought Marikana was bad, where we said that a mine worker had borrowed 1,000 rand,
yeah,
ended up paying 11,000 rand, and the legal cost of that was 10,000 alone.
Sure.
In that, and continued to pay. So the point I'm making is, if you compare notes, Marikana and this case here itself, I mean, it's big. The hole is so big, right? The people who get into those poverty traps those debt traps will never get out of it.
Right.
And that's why we came on in this matter. And then when we filed our papers on the 11th hour, we had to convince the judge why the Human Rights Commission needs to come in as amicus. We said that we have a story to tell, and it is a story that the judge needs to hear. And we demanded of the judge to do what we call judicial activism. Why? Because we are dealing with the power play. There's a huge disparity in the power play between the debtor and the creditor. Just to give you one example, in the case itself, the respondents, and that is the micro lenders, had 4 senior counsels, Ashraf, on their side. We had 2 junior counsels on our side. So it was a David Goliath story, and you know what legal fees is. It was a 5-day, the legal arguments went for 5 days.
Right.
And you know what the cost of legal, the working class person has problems just going to consult with an attorney because the fees are staggering. Imagine when a senior counsel with 30 or 40 years of experience goes and acts for the micro lenders. So you can understand why they've engaged the best in the country, because they've got that kind of capital to maintain a momentum.
No doubt. A huge industry with huge amounts of money. It might be a convenient time just to take a break. Please stay tuned and join us after the short break. Assalamu alaikum wa rahmatullahi wa barakatuh. And here's a reminder that you tune to Legal Ease, the show that converts legal jargon into legal ease. And tonight we're covering a very, very important topic, and that is of the impact of the Western High Court decision on emolument attachment orders. Now, I'm joined by Advocate Ameermia, who was saying to us just before the break that the industry is so huge that in certain cases, in this particular case, a large number of senior counsel were put together by the respondents to try and deal with the arguments put forward by the applicants. It is not surprising that some research has shown that there are almost 5 million emolument attachment orders. Other research has shown that at least between 10 and 15% of the workforce of South Africa have got emolument attachment orders against them. Now, this decision has been groundbreaking for a number of reasons, and helping us unpack the reasons, as I said previously, is Advocate Ameermia from the Human Rights Commission. But here's a reminder to our viewers as well, the lines are open. If you have any issues with your EAOs, then you may call 011-086-7777. That's 011-086-7777 with the questions. Shafie, we were just saying that it's a huge David and Goliath battle case here. But as friend of the court, you made application, and the judge was convinced that you would add value to the case. But in a way, hats off to the judge as well for judicial activism and for allowing you to get involved in this thing. So what happened then?
Okay. what happened in the case itself,
Yes.
right, is that obviously the respondents' arguments were basically to say that, listen,
Now the respondents are the micro lenders.
the micro lenders,
the 45
the 45
companies.
companies, okay, represented by a firm of attorneys called Fleming's Attorneys.
Right.
Now, what they said that, look, this is privity of contract between a debtor and a creditor.
Yeah.
Okay, and therefore the debtor knew what he or she was getting into.
Right.
So they can't come now later on and cry that they've been shortchanged.
Right.
That's the bottom line. Okay, and that was the old school of thought. They used to call it the positive school of thought.
Right.
And that required, at that particular point in time, for us as a Human Rights Commission to say no. But here we are looking at the dignity of human beings, right? A farm worker, in this case, will not have money to go from Stellenbosch to Cape Town. Where are they going to even get an attorney to represent them? That is one.
Right.
Two, we are saying that they have a right to dignity, right? And therefore, we said to the court that if you look at international best practices, if you look at the United States, you look at the UK, Germany, and particularly even Rwanda, right? Rwanda's got a cap on the kind of repayment that must happen at 25%. So those are international best practices which we convinced the court here. We said to the court, what you need to be doing is, in terms of the Constitution itself and the Bill of Rights, you must give effect to international law when you're giving judgments in our domestic district. What we asked of the judge in this case was to say that within the principles of justice and fairness, there is no justice and there is no fairness here. We're then calling you as a judge to pronounce on this matter, right, to champion the rights of the poor and the vulnerable, because they have a right to dignity.
Right.
That argument was upheld by us. Now, the reason why we said that, we said to the judge, look, this thing is not only confined to the farm workers in Stellenbosch.
Yeah.
The micro lenders have gone into the pockets of the pensioners. Okay?
Right.
And they're eating into the pension, the pay packets there.
Yes.
So they're causing a disaster there. The micro lenders have gone into the pay packets of civil servants as well. So what happens is, government has got money for service delivery.
Right.
But then you find everybody talking about non-delivery. And that's because somebody out there is not pushing paper to make it happen.
Right.
That's because they're trying to supplement the income by taking bribes.
Okay.
So it's basically becoming cancerous across society, the way the micro lenders are eating into the system. We then convinced the National Planning Commission as well, right? And we said the National Development Plan, which is a 2030 vision for South Africa, to close the gap between the rich and the poor.
Yeah.
And we said that will never happen, because come 2030, which is not far away, Ashraf, it's just
15 years.
It's 15 years, 3 elections away.
Yeah.
This government has to get its act in order to close that gap between the rich and the poor. Otherwise, there's going to be a disaster out here.
Right.
And we said to them that this is a cause for concern to everybody, and therefore this whole thing needs to be revisited.
Right.
Those arguments that we came before the court then, right, basically convinced the judge that, we had a just cause for which we had to intervene.
Let's just pause there. What were the facts that gave rise to this? Let's just give a background to this narrative, right? That there was a farm worker and he had to take a loan.
Yes.
So he approached one of 45 micro lenders.
Yes.
He signed a document.
Yes.
That's what the respondents were arguing.
Correct.
That he signed the document, so therefore the court should not interfere in contracts.
Yes.
Right. But your argument was, hang on, this is not a mere contract. This contract goes beyond the ordinary terms of payment. This contract impacts dignity, impacts the ability of a person to survive. I think what you said earlier on, a 200 Rand loan balloons into 7,000 Rands. I mean, at the farm worker's wage, how many years will it take? I mean, it might take his whole lifetime to pay. So that's caused the intervention. We have a call on the line. Caller, please go ahead.
Assalamu alaikum.
Alaikum salam.
I just want to ask those farm workers and those pensioners, can't they go for help to the South African Law Society in case they can't afford to pay me or legal representative.
So if I understand your question, farm workers could have gone to the Law Society for assistance.
South African law societies, they're supposed to protect the people who can't afford legal aid and legal representatives.
Okay, thank you for your
That's my
question. All right, thank you. Shafie?
Sir, walaikum salam. You are correct. They could have gone to the Law Society to ask for legal aid. But in this particular case, what has happened is that, you know, the individual farm worker was basically too busy trying to eke a living to even get access to that legal aid. What had happened in this case here is the owner of the farm picked up a problem that there was non-productivity on the farm, because all the money that was being paid to the farm workers were going into the pockets of the micro-lenders. And that was the concern. So it was more than that. So she then championed it through, on their behalf, with the Stellenbosch Law Clinic. And the Law Clinic basically assists vulnerable and poor people. We call it public interest impact litigation. So they, yes, you are right, they could have gone to the Law Society, but it seems that everybody at this particular point in time was sleeping. They were sleeping because, I mean, it was an individual farm worker who borrowed 200 rand, the other one borrowed 1,000 rand, and it went on like this. But as a collective, when you went across, you found that the big amount of money that was at stake is 1.6 billion rand. Now, going back to what Ashraf is saying, let's get back to how it happened. It happened as follows. In the law of contract, where a debtor and a creditor enters into a contract, ideally what should have happened is that if the debtor defaults, then you would go to the magistrate court in the jurisdiction where this debtor resides, and that is the Stellenbosch Magistrates Court. But what has happened here, and this is where we call the recklessness, and it's basically theft, it's beyond recklessness, it's just theft. Knowing full well that the debtor cannot even afford to go and buy bread in the local shop down the road, they then went, the respondents went to courts that were outside the jurisdiction of the magistrates court where these debts arose. For example, they went to Kimberley, they went to Krugersdorp, they went to Thohoyandou. Now, the debtor in Stellenbosch, obviously it was not even aware that there were judgments being taken out against them in those various jurisdictions. And to add salt to the injury, we even found that it was the clerk of the court with no judicial oversight from a magistrate that was merrily stamping away these things. And at the end of the day, the clerk of the court basically stamped away the livelihood of people to the value of 1.6 billion rand. That was the concern for the Human Rights Commission, to say that it could never have been the intention of the lawmakers, where we had commercial contracts like this, for them to be cheated of their livelihood. In other words, if there was the debtor and creditor entered into a contract, the rational thing would be a magistrate's court in Stellenbosch should have granted a judgment. Now, I know of situations in my investigation in this matter. There were people that had the audacity, the attorneys who had the audacity to go to places like Mokopong in the Limpopo province with plastic bag full, dustbin bag full of garnishee orders for a clerk of the court to have just stamped them away. The magistrate in that case said no to the clerk of the court, you will never do this in my court. So the attorney had the audacity to phone this magistrate and say to this magistrate, I will report you to the Judicial Services Commission and the authorities, you'll get fired. And he says, you can do what you want to, but what you're doing is unlawful and illegal.
That's an excellent point. We have another caller on the line. Caller, please go ahead. Caller, we can hardly hear you. Please speak up.
Hello.
Hello, yes.
Can you call me back at this time?
I'm sorry, what's your question? Okay, we've lost that caller. So, Shafie, what you're actually saying is quite dynamic. it started some time ago, like you identified, the Minister of Finance pointed it out. But here's a magistrate sitting in a court where none of these debtors are present, and he's saying this won't happen. Now he's threatened by the attorney that what you're doing is you're depriving me of my rights as a creditor, and I'm going to report you to the Magistrates Commission and other authorities. And that magistrate is standing up and saying no. So really, a commendable step. I think important to realize that behind the thinking of all of these judicial officers was that they had to have mercy for the man in the street, I mean, who was really forced in many instances to take out loans. And the difficulty with these was that the high and crippling interest rates, and the creditor wanting to enforce this. And in this case, Wendy Applebaum, who's the owner of the farm, she was vigilant because she saw a drop in productivity. I mean, she had the good sense of trying to investigate. Just to come back to the question by that caller about turning to the Law Society. Now, the Law Society regulates the attorney's profession. Before we continue, we have a call on the line. Caller, please go ahead. So, that caller we've lost. So, the Law Society would ask law firms to do this pro deo, but there are large groups like the legal aid and law schools, as in this case the University of Stellenbosch Law School, that took on the plight of the workers. So there are organizations out there to help. But very important, the Human Rights Commission stepped in accordance with its mandate to serve and encourage people to act within the Bill of Rights, and was joined in this matter. So we were saying that the judge basically, what did the Judge Desai find here? Well, what was his findings?
Judge Desai's findings were absolutely to the point. He first of all, in his opening remarks in his judgment, he said there was endemic abuse of the system, period. And then he lambasted the respondents for overreaching poor and vulnerable people.
Right.
He then said that access to court is a fundamental right. Okay. Now, if access to court is a fundamental right, the debtor should have been in court when the judgment was given. This didn't happen because, I mean, as I said, Ashraf, this poor farm worker cannot afford to even buy bread in Stellenbosch.
Yeah.
And even if you call him to come and consent to this thing and come and tell him that his case is going to be heard in Kimberley or in Mokopong or in Krugersdorp, where on earth is this man going to get money to get there in the first place?
Right.
Right. So what he then said, Judge Desai said, the ability to earn a salary is at the epicenter of the right to human dignity.
Okay.
Now that is fundamental, because this is the only thing that these farm workers have, Ashraf. They don't have attachable properties.
Yeah.
Okay. They're living at the mercy of the farmers.
Right.
On the farmlands. Right. Now there's nothing to attach there. So the salary, the wages that they earn, that's the real right, and that's the only right that they have.
Right.
Now you take that away from them, Ashraf. What are you doing? You're destroying the dignity of human beings. Okay. And therefore he said that, people have an access to socio-economic rights.
Right.
Right. And this is a limitation of that right. Then he went on to say to the world out there in his judgment, he then said, listen, that there has to be legislative intervention.
Right.
So he called upon the Department of Justice to urgently revisit the Magistrates Court Act to close that gap. The gap which allowed these people, the micro lenders, to do what they did. Because Section 65, right, read with Section 45, that's the consent principles, would never have been the intention of the legislature to have these kind of scenarios outside where the debtor and the creditor resides. It was also against the National Credit Act. Now remember, the Magistrates Court Act is a 1944 Act.
Yes.
The National Credit Act is a post-1994 Act.
Yeah.
Okay. Now obviously those apartheid legislation.
Yes.
totally inconsistent with the values of the Constitution
Right.
and the fundamental freedoms underpinned by dignity and equality, right? It could never have been the intention of any, the legislature to have a debtor suffer those kind of consequences, particularly in our country where the majority of the population in this country are poor, right? I mean, there's statistics that show there's some people earning $1.25 a day. That's,
Right.
That's how bad it is. And that's how, I mean, we're talking to the listeners out here. Obviously, most of them are working class or the middle class. But the majority of the people are trying to eke a living.
Right.
Now, this basically we're saying is the dignity that we're talking about.
Okay, on that point of dignity, we need to take another very short break. Please stay tuned. Assalamu alaikum wa rahmatullahi wa barakatuh. A reminder that you are tuned to Legal Ease, the show that converts legal jargon into legal ease. Tonight I'm joined by Advocate Mohamed Shafie Ameermia from the Human Rights Commission, and we're discussing the decision of the Western Cape High Court that has had a tremendous impact on the micro-lending industry, particularly with regard to emolument attachment orders. Now, just before the break, we heard that the main reason for the Human Rights Commission joining the action was because it wanted to preserve the dignity of the people. And the judge pointed out that a man's dignity resides in his ability to earn. If he doesn't earn enough, well then, his dignity is affected, and that has all kinds of other ramifications. Shafie, with regard to Judge Desai, I think he was saying that the Department of Justice had to be joined or had to intervene or had to be a respondent simply because the provisions of the Magistrates Court Act was out of tune with present-day legislation, particularly the National Credit Act. Now, that the Magistrates Court Act allowed what we call forum shopping, as you described it. The applicants resided in Stellenbosch, but the judgment was given in Da'a, and there's no way that he knew of it, and there's no way that he could go and resist it and represent himself. I think you mentioned there were 45 respondents in this matter. And how many farm workers were there?
There were 17 applicants altogether, Ashraf, 17 farm workers. There were 17 of them. But it was what you call a impact litigation thing, because what happened to these farm workers cut across the sector itself.
Right.
Because they always borrowing money.
Right.
That kind of thing. Now,
how does that impact the employer? Now, let's say I'm an employer and I'm obliged, when I receive the emolument attachment order served on me, I have to take off that 500 rand from the guy's salary before I do anything else. What are my role? What is my role as an employer? What is my duty, and can I disobey it?
I think it's a very good question that you ask, Ashraf, because now the law is very clear. This judgment has basically cleared that principle.
Yes.
This judgment has cleared the principle in the following sense. As from the 8th of July 2015, any emolument attachment order, call it a garnishee order, that has been issued outside the jurisdiction of the Magistrates Court where the debtor and creditor reside is unlawful, illegal, and unconstitutional. So as an employer, do not give effect to it. If you are threatened by the attorneys to say that they'll take action against you, report them to the Law Society.
Right.
Because the Law Society, in terms of this judgment, has also been ordered to investigate each and every attorney who is involved in this practice of debt collecting,
right,
to be investigated as well. So the judge has not minced his words there. So what we are saying to the employers, okay, whether they're factory owners, or whether they've got a good big staff complement, before they would say, you know what, I don't want to get involved in this, I'm just going to pay.
Yes.
Now, it is very clear that they cannot be threatened. I think it's not asking for too much, Ashraf, of an employer to at least interrogate whether the garnishee order was lawfully issued.
Yeah.
Lawfully in the sense that where the debtor and the creditor reside, does the magistrate's court in that jurisdiction where the debtor resides
Right.
issued the court order.
Yeah.
So that will determine the lawfulness or the unlawfulness of that garnishee order.
Right.
So therefore the employer doesn't have to be intimidated by these practices like what the magistrate did in Mokgopong.
Yeah.
He told him to go and fly a kite. That's the bottom line.
I think we must be very clear. It doesn't declare the contract, the underlying contract, to be illegal.
Yeah, absolutely.
What the judgment did was, it said, level the playing fields. You're not entitled to go forum shopping. Secondly, you're not entitled to go to the clerk of the court. What you need is judicial oversight, and you need the intervention of the magistrate. I think we just have another caller. Caller, please go ahead. Caller, we can't hear you. Have you got your TV on?
Yes, sir.
Okay, we can hear you now, but please turn down your TV, please.
Okay, fine. Yeah, I think now you hear me.
We can hear you. Please go ahead.
Yeah, in fact, I just listened to what you discussing there, both of you.
Yes.
But there's a problem here. Sometimes you owe the money and they charge you the attorney to pay that money. And then after paying the money, they put more money, they double the money. They take their money for them because they are attorney.
Yes.
What is the story then about that?
Okay.
If now I'm owing the money, I pay the loan, they garnish me and I pay that garnish. And then after that, after the garnish, they add more money, double the money they do pay. Is it fair in terms of the law?
Okay, if I understand you correctly, what you're saying is you pay the capital amount and then there's attorney charges. Are you obliged to pay the attorney charges as well?
Yes.
Shafie?
Yeah. I think, you know what, there is, in terms of the attorneys, the Magistrates Court Act itself, there's a tariff. Ashraf, and you cannot go beyond those guidelines as far as charges are concerned. In this case here, what has happened is, just to answer your question, if this attorney has charged you excessively, for example, you know where the capital and the interest is more than the capital, that alone should raise alarm bells, okay? Because obviously that is illegal. Now, where I gave you an example where this person borrowed 250 rand and had to pay 7,800 and some odd rand, that is daylight robbery. Okay, that attorney must be taken to task. You need to report that attorney to the Law Society, and that attorney needs to be investigated. I'll give you one example. There was, in my own office, it happened to one of my staff members. Immediately after this judgment was handed, she got back, she out of 22,000 rand that she borrowed, she had to pay over 45,000 and she was continuously paying that. When this judgment was delivered, they got a call from that attorney's firm to say, you know what, give us your banking details, we'll pay you back the amount of 11,000 rand. So I think the attorneys are fully aware of this judgment. And now that it is a reported judgment, it makes it even more stronger. Where if attorneys act recklessly the way they want to do, in this case, believe me, the Law Society, the law was going to take its course on them. And we, the Human Rights Commission, are going to make sure that we're not going to allow this practice to carry on any further. I think, you know what, we're dealing with huge poverty traps in our country. People are really, really poor, and for these micro lenders who are now overreaching us, it is totally unacceptable. Totally unacceptable. As I said, it's an industry that grew from 41 billion rand in 2007 to 159 billion rand, and that's a lot of money. I don't even know how many notes there are in a billion. Just to give you that example, imagine this person who's trying to just bring some money home to pay for the school fees, to bring food onto the table. Those are the kind of people that we're talking about. So these micro lenders, these 45 of them, is just the tip of the iceberg. of a bigger problem that's in this country. And that now this is where we're coming to the judgment itself. This judgment is now saying, Department of Justice, you had known about this problem since 2008. It was brought to your attention. There was a bill in Parliament that was now shelved. When, Ashraf, you raised a very important question was, what is the Department of Justice doing now to close the gap? They were taken to task by the judge in this case to say to them that you knew that this practice was going to happen. You allowed this practice to happen. Okay? Why didn't you pass and act the law in Parliament? Why did you sleep on it as well? And you know, he gave them a time frame within which to close that gap immediately. Right now, there's an amendment to the act itself, the bill. It's going before Parliament to close that gap. Particularly, this is where we want judicial oversight, and we don't want the clerks of the court to merely stamp away garnishes, emolument attachment orders. So what the judge has made even more pronouncing in this case is the fact that we're looking at the Department of Trade and Industry as well, and the National Credit Regulator that has to revisit the National Credit Act itself to close this gap. We think that it should, the maximum that you must allow a person who's involved in such kind of debt to repay is 25%. Because Rwanda, we got an example from Rwanda. In Rwanda, this is what they're doing. So it's on the African continent, it's part of international law. The reason why we're saying is, yes, people will get into debt. All of us do get into debt for some reason, out of necessity. But obviously, we also need to take money home to buy food, pay for our electricity, right? Pay our rent, pay our bonds. Now, if you take everything away from that, where on earth are people going to get that additional money to meet their basic, daily needs? I think that's the problem, Ashraf, that we're sitting with here. It's a major, major problem. And so what is happening now is that Parliament is now basically alive to the issues. The Law Society has also been ordered by this judgment to say that all the attorneys, and I'm saying this I'm not mincing my words, all the attorneys that have been involved in this kind of practices know that the law is going to come after them, big time. And these service providers, what they're going to do now, a lot of them, they'll probably try and liquidate as well. But then the Department of Trade and Industry are going to take, are aware of these kind of practices, because what's going to happen is, Ashraf, once, the liquidation takes place,
yes,
the debtors are going to suffer even further, because right now the debtors must get back their 1.6 billion rand.
So that's the very important point. Now it's another convenient place to just pause for a break. Please stay tuned and join us after this break. Assalamu alaikum wa rahmatullahi wa barakatuh. And here's a reminder that you're tuned to Legal Ease, the show that converts legal jargon into legal ease. And tonight, joining us in our discussion is Advocate Mohamed Shafie Ameermia from the Human Rights Commission. And we're paying particular attention to the Western Cape High Court's decision in July regarding the status of emoluments attachment orders. Now, you'll be surprised to know that this does just not have a negative impact on the employees, but on the employers as well. Shafie, there were a number of recommendations made. How does it impact on the employer?
For an employer, Ashraf, what happens is the debt affects employers. Okay, yeah. There's financial distress that spills over in the workplace.
Right.
Okay, decreased productivity, mental exhaustion, physical illness, absenteeism, low pay satisfaction, and fraud and corruption for subsistence.
Yeah.
That is what employees go through, and this is what employers pick up. And then obviously, if they do not have adequate health and wellness programs in their enterprises, what happens is that obviously, the business goes down. Okay.
Right.
So now, what can employers do? I think the first thing that employers can do is, and it's not asking for much, is to audit existing emolument attachment orders for any irregularities if they suspect something like that is happening.
Yes.
The training of payroll officers and administrators in the employment area, right, to able to administer the emolument attachment orders,
right,
for its lawfulness and its correctness as well.
Yes.
Right, because a debt has a beginning and an end life.
Right.
You can't continue paying all the time.
Yeah.
Right, and so that's what they should be. That's what they should be on guard for. Now, what happens is, we are saying that sometimes you need to outsource administration of emolument attachment orders.
Right.
What we are then saying there is basically you need to know the law. Systems must be in place, and that also is convenient and financially viable for big enterprises to have payroll administrators,
yes,
to protect that the industry itself from this kind of abuses.
Yeah.
Now, obviously, what can the employers do? The employers can perhaps, what we're saying they should be doing, is engage in wellness employee wellness management programs.
Right.
Because Ashraf, we just assume that once you get a paycheck, you know how to run your finances, and that's not true.
Yeah.
People, once who just come out of universities or high school and just get the first paycheck, what do? They do not even think of the consequences of going into debt. So you need to teach them how to do financial management and plan. You see, so these are the kind of things that you can engage with your employees. Okay, so we are encouraging from the Human Rights Commission also, in as much as it is difficult, to live within your means. Okay,
yes,
and be responsible for your finances. When you get your 13th check, it could be that check that pays for the child's school fees in the next year.
Right.
So don't just, merrily spend it away over Christmas pudding or something like that.
Right.
Over the festive period, and then you get into distresses later on. So these are the kind of things that we thought must be brought to the table as well. So once we get a responsible and active citizenry,
yes,
that manages its finances well, obviously the economy will take a different,
right,
a swing,
yes,
for the better of everybody else.
Well, we've run out of time, unfortunately, and just leaves me a few seconds just to thank you, the viewers, for having joined us, and our very special guest, Mohamed Shafie Ameermia, an advocate in the employ of the Human Rights Commission, who was entrusted with this matter of representing the Human Rights Commission as amicus curiae, or friend of the court, in a very, very important judgment that sought to protect the dignity of the workers that were exposed to huge amounts of court actions that they had very little control over. Thank you for joining us, and we will join you next week again. Assalamu alaikum wa rahmatullahi wa barakatuh.
Thank you very much, man.